If you're arrested for DUI, is it possible to beat your case in criminal court but still lose at the DMV? Is it possible to beat your case at the DMV but then still lose in criminal court? We'll try to answer these and related questions in this video. As you've seen throughout our videos, following arrest for DUI in California, you have to be worried about both the DMV and the criminal court. There are two separate entities that are both going to determine how your license and your liberty are going to be affected in some way following your DUI arrest. Today, I want to build off some of our other DUI defense videos and just talk straightforward a couple different hypotheticals that come up in preparing for the DMV defense and for defense in criminal court. And as we can see in other videos here, even though they're all the government, they act separately and they deal with issues that are similar but technically different. I'm going to show through a couple of hypotheticals how these issues play out. Let's talk about one situation. You get arrested for DUI and you schedule a DMV hearing. At the DMV hearing, you and your attorney are able to convince the DMV hearing officer that your license should not be suspended. The DMV issued what's called an order of set-aside. That's a victory at the DMV. But then you go back to court, and then in court, you get found guilty of DUI. Are you going to get suspended? Well, unfortunately, the answer is yes. In that scenario, the DMV is going to end up ordering a suspension. So some people might think, oh, isn't that double jeopardy? Well, it's actually not. The DMV did just give you a victory, but then the DMV just learned from court that you were just found guilty beyond a reasonable doubt of violating one of the DUI laws. And being found in violation of one of those DUI laws, unfortunately, is a ground of suspension. Let's say you don't reserve a DMV hearing. You're too late to have one, and then the DMV suspends you when they review the evidence and determine that you had too much alcohol in your blood or your breath. Then you go to court, you go to trial, and you get found not guilty. What happens then? Well, in that case, actually, your suspension is going to get reversed. If you go to trial and get acquitted of DUI, then that reverses many grounds of suspension the DMV may have held over against you. The exception, a big exception, is refusals, as I mentioned in another video. So if they suspended you from the start for being a refusal, you're not guilty in criminal court isn't going to get you anywhere. But if your initial suspension was for the basic having too much BAC in your system, that not guilty you just got is going to reverse that suspension. Good for you. So let's say hypothetically in another situation, you go to court and you get your DMV hearing reserved, and you go to court and your DUI case gets dismissed. Let's say, for example, you get it dismissed through a successful grant of military diversion, or maybe you succeed in litigating a motion to suppress. You prove that the officers had no basis to pull you over, and so all the evidence from your traffic stop gets thrown out. Well, that's all great. You're going to get out of this without a criminal record. That's wonderful. But the DMV still has the authority to suspend you. And in this case, where hypothetically you get the case dismissed, but the tests are showing that you're noticeably above 0.08, the DMV might still have a righteous ground to suspend you, and you got to prepare for that possibility separately. Mind you, however, on the issue of suppression hearings, the DMV in many cases does still have to consider whether or not you were lawfully arrested. And so if you were able to win that issue in a motion to suppress in criminal court, for example, proving that they had no basis to stop you and you're not lawfully arrested, you can argue that same issue over at the DMV. Well, this prompts another hypothetical. If you just got the motion to suppress granted in criminal court, a 1538 motion as people call it, doesn't that judge's ruling carry over to the DMV? Doesn't the judge's ruling that you were unlawfully arrested mean the DMV have to rule the same thing? Well, unfortunately, the answer to that is no. The courts have ruled that the DMV and the DA offices are actually not in what's called privity with each other. And so therefore, the DA losing in a motion to suppress a DUI case in criminal court, it doesn't actually bind the DMV to make a similar finding. But you should probably prepare to litigate the same issue at the DMV in that scenario where you beat your DUI case on the grounds of unlawful arrest. So think about that one too. Let's say hypothetically you get your DUI reduced to a type of reckless driving, wet or even dry reckless. Those are some advantages because it's a shorter period of probation, usually lesser penalties. But the DMV is looking at your report and they see that the numbers are showing you're still above 0.08. In that scenario, what happens? Well, being convicted of wet reckless is not actually going to cause a license suspension. That's good. Okay, so be able to walk out of court still with a valid driver's license intact. However, in that scenario, if the DMV hasn't ruled yet, then you still have to prepare yourself for the possibility of a suspension. The difference, though, is that the DMV ruling will happen at a later time. On the contrary, if you get arrested for DUI and then have your DMV hearing reserved get found guilty of DUI, but the DMV hasn't given you a ruling yet on their end, the DMV hearing is almost meaningless in that scenario. Your conviction of a DUI triggers a suspension. Note, however, if there are other grounds of suspension, like a refusal, then that issue is still worth litigating even if you have lost your DUI case in criminal court, if you got found guilty of DUI there. Let's say hypothetically you get found guilty of regular reckless driving. Doesn't even count as a prior DUI offense in criminal court. Well, surely in that scenario, the DMV would go ahead and leave you alone. Nah, not so much. Yes, a reckless driving conviction itself does not trigger a suspension. So the fact of that conviction is not going to cause your license to be suspended unless the reckless driving conviction just caused you to have too many points on your license. Unlike a traditional DUI conviction, a reckless driving conviction, again, does not itself cause a suspension. However, the DMV still has the authority to suspend you if it feels that it has the jurisdiction to do so. Now let's talk about one last one. Suppose that you get arrested for DUI, you never reserve a DMV hearing, and the DMV goes ahead and suspends your license. And then after you've been serving or even served that suspension, you go to court and you and your lawyer negotiate a reduction to wet or dry reckless driving. Does that mean your suspension is going to get doubled up? No, because remember, like I said before, the reckless driving convictions themselves are not necessarily grounds for suspension, certainly not on first offenses. There is one exception though. If you are under 21 and you're found guilty of wet reckless at the time, that fact of that conviction for being convicted of wet reckless growing out of an arrest when you're under 21, that arrest under the law does actually trigger a suspension. It's unclear how often the DMV is actually enforcing this right now. I'm basing this off personal experience, but perhaps that could change at some point when this video is viewed. There is legal authority for the DMV to suspend you for wet reckless conviction if the wet reckless occurred when you're under 21. But if you're over 21, the wet reckless conviction does not actually trigger any kind of suspension. Now, actually, one more right here. You get arrested for DUI, and there's no alcohol in your system at all. But through a lot of testing to determine there's narcotics in your system. Is the DMV going to suspend you? Well, hopefully not, because there's no alcohol in your system. So the only real ground for the DMV to suspend you out of the gate before everything is done is if they determine that there's too much alcohol in your system. If they see there's no alcohol out of the gate, I mean, I wouldn't recommend doing this. It's always best to reserve a hearing, but even if you don't reserve a DMV hearing, the DMV might not suspend you at all. So unless your case is a refusal in that scenario where you get screwed for refusing the request for testing, you shouldn't be worried about a suspension in that scenario. But let's say you go to court and you get found guilty of DUI under the influence of drugs within subsection 23152 of the vehicle code. Well, in that scenario, the DUI conviction, like I said before, itself triggers a suspension, even though you beat the DMV earlier by not having any alcohol in your system. They see you're found guilty of DUI beyond a reasonable doubt, that's going to trigger a suspension. And in fact, when it's guilty of DUI drugs, you might be facing a much stiffer, longer suspension than if it were DUI alcohol. Let's say hypothetically, you don't get any suspension initially because there's just narcotics in your system, and then you get it reduced to wet or dry reckless driving. Once again, unless you're under 21 and unless there's a refusal, you are fine. You're not getting any type of suspension based on that, based on the fact of that conviction. Now, this will be the last one, actually, I promise. Let's say hypothetically you get arrested for DUI. You have nothing in your system and you really don't care for the officers messing around with you. Understandable reaction. So when they tell you that they want to draw blood from you after the arrest, you tell them, no, I'm not agreeing to anything. Okay? And they get a warrant, they draw the blood. They draw the blood and it turns out, of course, there is nothing in your system. You were right all along. However, even though the DA is not going to bring charge in that situation, or at least they certainly shouldn't, or they're certainly not under a DUI section, the DMV is still, unfortunately, going to come after you for refusing the officer's request for a test. And unfortunately, you could be looking down a very stiff, very long refusal suspension simply because you refused the officer's request for a chemical test, even though it turned out that you had nothing in your system at all. Crazy. A type of suspension that, when all said and done, really has little to do with DUI and all, but that is something that can happen. Well, that was a lot. I certainly hope that this was helpful. If you or anybody you know is concerned about fighting a DUI charge, please give us a call. Thanks and stay safe out there.